Okay, I'm reading Chapter 3 from California Civil Procedure Handbook, Rules, Selected Statutes and Cases, and Comparative Analysis. Beginning on page 45, titled Pleadings, Subpart A, the Complaint 1, Code Pleading. California's pleading system derives from the field code reforms of the mid-19th century. New York's adoption of the Code of Civil Procedure followed closely upon the 1848 report of the Commissioners on Practice and Pleadings of New York and its head, David Dudley Field. California, which joined the Union in 1850, chose the modern system of the time for its pleading model. The Field Code abolished the common law forms of action, merged law and equity, limited the types of pleadings, limited the effects of technical errors, and required pleading only of the facts constituting the cause of action. See CCP 370, 422.10, 425.10, and 475. California remains nominally a code pleading state. It has declined to follow the notice pleading model of the federal rules. Section 425.10a still requires the complaint to contain a statement of the facts constituting the cause of action in ordinary and concise language. However, California has liberalized the code pleading requirement. Case law reflects a reduced concern with pleading ultimate facts in precisely the correct format. Although the elements of a cause of action must be present in a pleading, if this allegations give sufficient notice of plaintiff's factual theory, this is usually sufficient. Alternative and inconsistent theories may be asserted, citing Shepard and Morgan v. Lee and Daniel Inc. of 1982. Joinder of claims and parties has been liberalized by adopting rules similar to, and in many cases identical to, the federal rules. Amendment is liberally allowed through trial. The Judicial Council has also adopted official form pleadings, complaints, cross-complaints, and answers for several basic types of claims and causes of action. See CCP 425.12. Identifying California as a code pleading state is thus both misleading and an oversimplification. Section 422.10 lists the pleadings in California courts. The pleadings allowed in civil actions are complaints, demurs, answers, and cross-complaints. A demonstrative case provided in the text is Semel versus Sanssouci. This is heard at the Court of Appeal, 2nd Appellate District in California in 1972. The acting presiding justice, Herndon, gave the opinion. Appellants appeal from the order dismissing this action brought against respondent to recover damages for wrongful death. The dismissal was entered after respondent's demur to appellant's second amended complaint had been sustained without leave to amend on the ground that no cause of action had been stated. The original complaint, filed on July 11, 1966, alleges that on May 9, 1966, appellant's son, John Semel, was fatally injured while loading piggyback trailers onto railroad flat cars. It named as defendants the decedent's employer, Pacific Motor Trucking Company, and a fellow employee, Robert J. Sanssouci, respondent herein, and Tendos. On December 11, 1970, the court below granted the motion of the defendant corporation for summary judgment and dismissed the action as to that defendant on the ground that the action against the decedent's employer was barred by Labor Code Section 3601, which, with inapplicable exceptions, limits the remedy to the recovery of workman's compensation. Appellants took no appeal from that judgment but have sought to maintain the action against respondent, decedent's fellow employee, by invoking Labor Code Section 3601, subsection A3, which read at the time as follows: where the conditions, this is subpart A, where the conditions of compensation exist, the right to recover such compensation pursuant to the compensation exist, the right to recover such compensation. I'm sorry, I reread that. Where the conditions of compensation exist, the right to recover such compensation pursuant to the provisions of this division is, except as provided in Section 3706, the exclusive remedy for injury or death of an employee against the employer or against any other employee of the employer acting within the scope of his employment, except that an action at law for damages against such other employee as if this division did not apply in the following cases. 3, when the injury or death is proximately caused by an act of such other employee which evinces a reckless disregard for the safety of the employee injured and a calculated and conscious willingness to permit injury or death to such employee. Respondent filed a general demurrer to the complaint and sought a dismissal of the action on the grounds 1, that summons was not served upon him within the 3-year period as provided in the Code of Civil Procedure Section 581A, and 2, that the action was barred by Labor Code Section 3601. The trial court refused to dismiss the action on the first grounds, but sustained the demurrer without leave to amend on the ground that the complaint did not allege facts sufficient to state a cause of action under Labor Code Section 3601, subdivisions A3. Plaintiffs filed a first and a second amended complaint. In each case, defendant demurred on the grounds that a cause of action under Labor Code Section 3601, subdivision A3 had not been stated. The last demurrer was sustained without having leave to amend pursuant to points and authorities filed. Thus, the first issue presented is whether or not the second amended complaint alleges facts sufficient to state a cause of action. The complaint does set forth facts sufficient to state a cause of action. The earlier versions of the complaint charge respondent with negligence and reckless disregard for the safety of others. Since this action is subject to the provisions of Labor Code Section 3601 above quoted, they are manifestly insufficient to state a claim, for they fail to allege the calculated and conscious willingness to permit injury or death required by the statute. In an effort to remedy the indicated deficiency, the second amended complaint, the charging allegations of which are set forth in full in the paragraph foot note 1, that this action is brought pursuant to blah blah of this Labor Code, included an allegation cast in the words of the statute, citing a rule that allegations of willful misconduct require that the facts must be stated more fully than in ordinary negligence cases, citing Snyder v. Woodson. No date. 184 cal.app.2d211 from 7 cal.reporter.353. Respondent contends that the complaint must be held inadequate. No cases dealing precisely with the question before the court have been cited, nor has our independent investigation uncovered any, and so our inquiry must necessarily be rooted in general principles. It is well settled that in considering the sufficiency of a pleading, we are bound by the rule that on appeal from a judgment entered on demur, the allegations of the complaint must be liberally construed with a view to attaining substantial justice among the parties. CCP Section 452, Youngman v. Nevada Irrigation Dist from no date, again 70 cal.2d240, as in 74 cal.reporter.398, 449p.2d462. Obviously, the complaint must be read as a whole. Smith v. Kern County Land Co. No date again, 51 cal.2d205, 207, paren 331p.2d645. And each part must be given the meaning it derives from the total context wherein it appears. The Supreme Court has consistently stated the guideline that a plaintiff is required only to set forth the essential facts of his case with reasonable precision and with particularity sufficient to acquaint the defendant with the nature, source, and extent of his cause of action, from Youngman again and Smith. Youngman v. Nevada, Smith v. Kern. It has also been stated that the particularly required in pleading facts depends on the extent to which the defendant, in fairness, needs detailed information that can be conveniently provided by the plaintiff. Less particularity is required where the defendant may be assumed to have knowledge of the facts equal to that possessed by the plaintiff. Jackson v. Pasadena City School District 59 Cal. 2D 876 and 87 31 Cal. Reporter 606, 382 P. 2D 878. And Burks v. Poppy Construction Company 57 Cal. 2D 463 20 Cal. Reporter 609, 370 P. D 2D 313. This seems particularly applicable to a wrongful death action where none of the plaintiff heirs were present at the site of the fatal injury. Finally, it must be noted that the modern discovery procedures necessarily affect the amount of detail that should be required in the pleading. See Dahlquist v. State of California, 243 Cal. App. 2D 208, 212 through 213, 52 Cal. Reporter 324. Applying these principles to the case at bar, we hold that the complaint, although hardly a model of a pleading, stated a cause of action. The statutory requirement is that the death be caused by a fellow employee's act which evinces a reckless disregard for the safety of the employee injured and a calculated and conscious willingness to permit injury or death to such employee. Labor Code 36.0, subdivision A, 3. In substance, the complaint alleges that respondent failed to inspect the area into which he was backing and that he acted with the state of mind required by the statute. Respondent contends that paragraph X of the complaint is only a characterization, a conclusion of law with no additional factual support. The distinction between conclusions of law and ultimate facts is not at all clear and involves at most a matter of degree. Citations omitted. For example, the courts have permitted allegations which obviously included calculations of law and have termed them ultimate facts or conclusions of facts. From Burks v. Poppy. In Smith v. Kern, Supra, the issue was whether an allegation that defendant desired and wished that plaintiff come onto his land to remove tree stumps and roots was a sufficient averment of plaintiff's status as an invitee, not a licensee. The Supreme Court ruled at page 208, this allegation is not, as defendant contends, a mere conclusion of law. The cases it relies on are readily distinguishable. Wheeler v. Oppenheimer, 140, Cal. App. 2D 497, 295 P. 2D 128, held only that the technical term bad faith was a conclusion of law. Faulkner v. California Toll Bridge Authority, 40 Cal. 2D 317, 253 P. 2D 659, held to be legal conclusions and allegations that an investigation was insufficient and that acts were arbitrarily capricious, fraudulent, wrongful, and unlawful. The applicability of each of these words depends on more than, as in the case at bar, the mere presence of a state of mind. The pleading in the case at bar is not as clearly susceptible to that distinction as the pleading in Smith, but we do feel that the allegation here possesses enough of a factual thrust that we cannot agree with the respondent's contention that it is only a characterization that adds no additional factual support. In Jones v. Oxnard School District 270 Cal. App. 2D 587, 593, 75 Cal. Reporter 836, the court